For over 100 years, New York's one-inch rule stated that tenants were allowed to withhold all rent if a landlord evicted them from even 1 inch of leased space. But may a tenant really withhold millions in rent over a 1-inch eviction? The New York Court of Appeals explored this question in Eastside Exhibition Corporation versus 210 East 86th Street Corporation. The 210 East 86th Street Corporation owned a building. Eastside Exhibition paid the corporation almost $3 million to convert the building's first 2 floors into a movie theater and signed an 18-year lease for the space. A few years later, without Eastside's permission, the corporation added metal cross braces to the building's first floor to support some new construction. The braces took up about 12 square feet of space, less than 0.1% of Eastside's total leased space. But the braces were installed right in the middle of the theater's lobby, cutting it in half. The braces also clashed with the theater's décor and slightly reduced the size of a waiting room on the theater's second floor. Eastside sued the corporation, claiming that it had partially evicted Eastside by putting the unwanted braces in its leased space. Eastside refused to pay any further rent, invoking a common law rule allowing a tenant to withhold all rent in response to a landlord's partial eviction. The trial court ruled that the corporation's intrusion was too small to justify withholding rent and ordered Eastside to pay back and future rent. Eastside appealed. The appellate court reversed. Although the appellate court agreed that the eviction was too small to justify withholding all rent, it ruled that Eastside was allowed to recover its actual damages and remanded the case to determine those damages. Back in the trial court, Eastside's experts testified that the complex nature of the movie theater business made it impossible to determine what specific amount of money the theater was losing due to the braces. The trial court ruled that Eastside had failed to prove actual damages and that it owed the full amount of rent. The appellate court affirmed the order. Eastside appealed to the New York Court of Appeals.